5:18 p.m. on Saturday, by the way, May 13th, 2023. 82 years, short of one day, right? Right, short one day, 82 years. Lee Pearson versus William H. Pearson et al. 150 SW2D Series 788. Venue, mortgages. Venue in a suit to foreclose a mortgage on property lies in the county where the property is situated, and the holders of a second lien on said property, having no other interest therein, are not entitled to a change of venue to have said case moved to the county of their residence. What else does it say? That's the specific determination here. But this is not all that happened on this day, including going before Mr. Presiding Judge Harvey. Unfortunately, the intent of the consideration herein and what this pertains to may be challenged by, or may have a challenge inherent in the determination in this case. You know, at 82 years old, i.e., Harvey in Dallas wasn't the same as Harvey in Harris, was it? No, it wasn't. Harvey in Houston is not the same as Harvey in Tarrant, is it? No, it's not. Hold on, though. City of San Antonio et al. Versus McKenzie Construction Company. 150 SW2D 989. 1. Jury. Misconduct verdict. Where a jury is guilty of misconduct and, from the record, the appellate court is doubtful as to whether such misconduct affected the verdict on any material issue, the verdict should not be permitted to stand. 2. Evidence, conflict, findings. Where there is a conflict of evidence touching the question as to whether misconduct of a jury actually occurred, the finding of the trial court, either expressed or implied, is final. 3. Misconduct, question of law or fact. A misconduct on the part of the jury that is calculated to result in an injury to a part litigant is a question of law, while a conflict in the evidence as to whether a misconduct actually occurred is a question of fact. 4. Misconduct evidence duress. Where the evidence showed that a member of the jury during the trial of the case had written a letter to one of the attorneys for the defendant, asking for the attorney's influence in securing a job after the case was concluded, and the further evidence that this said juror was not in accord with the other members of the jury until he was reminded of such letter and told that it might lead to trouble. It cannot be said that the question as to whether said juror's verdict was untainted with duress is free of doubt, and the appellate court correctly reversed the judgment because of misconduct on the part of the jury. 5. Misconduct motions judgment. A litigant, by filing a motion for judgment, either on the verdict or notwithstanding the verdict, does not waive his right to later file a motion setting up misconduct of the jury. 6. Question of law, misconduct. Where it is conclusively shown that there was a misconduct of the jury, the question of whether such misconduct might have affected the verdict becomes a question of law for the court to decide. 7. Contracts, arbitration, and award. When the parties to a building contract agree to submit questions in relation to the work to the decision of a named engineer, the decision of the engineer is final and conclusive unless in making of his decision he is guilty of fraud, misconduct, or such gross mistake as would imply on his part bad faith or failure to exercise an honest judgment. 8. Arbitration and award judgment. Where in a contract for the construction of a dam, a named engineer is called upon to determine all questions bearing on the material and work. Such decision cannot be set aside simply because some other engineer would have acted differently or because of a conflict in evidence as to what he ought to have decided, as his decision as an arbitrator upon matters submitted to him has the same effect as the judgment of a court of last resort, and all reasonable presumptions are indulged in favor of his award, and the courts will not overthrow it except in a clear case of fraud or bad faith. 9. Contracts, payment, interest. In a building contract which provides for delayed payments and stipulates that, quote, then the city shall pay to the contractor, in addition to the sum shown as due by such statement, interest thereon at the rate of 8% per annum from date due as provided in paragraphs 24 and 26 thereof until fully paid, end quote, Interest is collectible only on the sums owing by the city, as covered by the statements made by the engineer. Really? Oh, we're not done yet. Citizens National Bank in Abilene versus Texas and Pacific Railroad Company et al. 150 SW2D Series 1003. 1. Contracts. Intention of parties. Courts. Courts will not resort to arbitrary rules of construction when the intention of the parties is clearly expressed in unambiguous language, but they will look to the language used in the contract itself to ascertain the manner and extent to which the parties intended to be bound, which interest and purpose will control. 2. Construction of contract intention of parties. In the construction of contracts, the entire instrument must be looked to and all its provisions construed together in order to determine the purposes of the instrument and the intention of the parties. A single paragraph, clause, or provision cannot be taken alone to arrive at the meaning of the contract. 3. Contracts, parties. Parties are presumed to contract for themselves, and a third person must, in order to have the right to enforce a contract to which he is not a party, show that it was executed for his benefit. 4. Contracts, liens, assignments. The proviso in a construction contract by a railroad company that, quote, after the contractor has furnished written evidence that he has paid in full all amounts that may be due by him, end quote, to certain named classes of persons, was placed therein for the benefit of the railway company alone, to protect it against others who might claim liens against it, and the work having been done by the contractor and accepted by the railway company, it is legally and equitably bound to discharge its obligation to pay for the services performed to the contractor or the assignee to whom he has assigned his contract. But we're not done yet. L.J. Vanover versus Barry Min Henwood, trustee for the St. Louis Southwestern Railway Company of Texas. 150 SW2D, Series 785. 1. Practice, special issues, judgment. In an action against a railway company to recover damages for injuries sustained by child while playing with a push car in the yards of the defendant, it was error for the appellate court to reverse a judgment for plaintiff because of lack of a finding by the jury that the said car had been habitually used by the children of the neighborhood with the knowledge of defendant company, when such issue was not an essential element of the cause of action and no request had been made for its submission to the trial court. 2. Judgments, briefs, jurisdiction, appeal, and error. Where the Supreme Court has determined that there was error in the judgment of the Court of Civil Appeals, and defendant in error has not filed an application for writ of error in the Supreme Court, said court has no jurisdiction to grant him relief, unless from an examination of his briefs as appellant in the Court of Civil Appeals, a right to which he is entitled, the court shall determine that the judgment of the Court of Civil Appeals should be affirmed upon the ground different from that upon which its judgment was based. 3. Charge of court, unavoidable accident, burden of proof. Where special issue submitting the question of whether the accident was unavoidable or not, though expressed in unusual wording, clearly and effectively placed the burden of proof upon the plaintiff, and there was nothing in said instruction to condemn it as a general charge, it was only a permissible charge on the burden of proof. 4. Railroad's knowledge. There is no distinction between a case of children playing with a push car, which jury found was attractive to them and could be easily pushed along the ground, and an ordinary turntable case, as in either instance it was the duty of the railroad company to exercise ordinary care to prevent injuries to children playing around same, regardless of any knowledge on the part of the defendant company that they had theretofore done so. But we're not done yet. Target, May 21st, 1941. Behar County et al. Versus Ray Hatley et al. 150 SW 2D Series 980. 1. Counties, commissioners' courts, elections, voting machines. An order of a commissioner's court which is in substantial compliance with the statutory article which permits said commissioners to adopt voting machines at any time for use in such voting precincts as they may deem advisable is sufficient to adopt the use of voting machines in elections held in the county. 2. Presumptions, Commissioner's Court budget. In construing the acts of Commissioner's Court, the presumption is to be indulged in favor of their validity, and where they are clear and explicit, they alone should be looked to for the intention of the court in passing them, and mere inferences or surmises cannot prevail against the unambiguous recitals of such orders and judgments. 3. Courts, counties, budgets, amendments. In the absence of fraud or abuse of their discretion, a commissioner's court has the authority to amend its budget to meet the emergencies that might arise from public necessity that could not be anticipated when the budget was originally prepared and adopted. 4. Voting machines, elections, commissioners' courts. The act of the commissioner's court in amending its budget previously adopted, providing for the use of voting machines instead of the ballot system as originally provided for, was well within their discretion, as there was no additional expenditure of money, but the same appropriation was used to accomplish the same result in a different manner as a public necessity. 5. Burden of proof injunction. Where one seeks an injunction to forbid a commissioner's court from expending money for the rental of voting machines, the burden of proof is upon such plaintiff to establish the fact that the funds are not available, especially when the court, in its order of adoption of said machines, stated that the funds were available. 6. Debt, contract, voting machines. Since the debt sought to be created, election expenses, was payable out of the current revenues of the county, the contract to rent voting machines to be used at elections held in the county was not void and unenforceable. Well. Really? But we're still not done yet. Again, May 21st. J.R. Miller et al. Versus County of El Paso, Texas et al. 150 SW2D Series 1000. 1. Local and special laws. The purpose of the constitutional provision that prohibits the passage of local or special laws for certain named purposes was to secure a uniformity of law throughout the state and to prevent the granting of special privileges. 2. Legislature, local and special laws. Notwithstanding the constitutional prohibition against the passage of local and special laws, the legislature has power to make classifications for legislative purposes and may enact laws intended to apply uniformly to all who may come within certain classification designated within the Act. Such classification may be broad enough to include a substantial class based on characteristics distinguishing that class from all others. A mere arbitrary device resorted to for the purpose of giving a local law the appearance of a general law will not be permitted. 3. Counties, advertisements, special and local laws. Where the classification for a legislative act is based entirely upon the population of a county and that of a city within that county, which condition applies to only one county within the state, an act which does not indicate how said county would be a suitable or peculiar field for the expenditure of public funds for advertisement purposes to promote the growth and development of same, would be a special law, as such limitation bears no substantial relation to the object sought to be accomplished, nor does it constitute a class as distinguished in any substantial manner from the other counties of the state. 4. Counties, municipal corporations, advertisements, public funds. A county, being a mere subdivision of the state, can exercise only government functions, while a home rule city may exercise proprietary functions and, if authorized by its city charter, may expend its public funds for the purposes of advertising its own resources. Well. But we're still not done yet. May 28th, 1941. Great Southern Life Insurance Company versus Ethel Mary Doyle et al. 1. Life insurance reinstatement consideration contracts. Where a life insurance policy provides conditions upon which it may be reinstated after it has lapsed for non-payment of premium, the company has no right to add a condition precedent not mentioned in the original contract to the taking effect of the reinstatement of the policy, as the insurer may not enlarge the terms of the original contract or impose additional conditions unless same are supported by a consideration. 2. Insurance, representations, fraud, statutes. Subdivision 4 of Article 4732 RS 1925, providing that statements made by the insured in an application for a life insurance policy in the absence of fraud are representations and not warranties, has no application to a request for a reinstatement of a life insurance policy to the extent of permitting the incontestable clause contained in the lapse policy to preclude a defense of fraud in procuring a reinstatement of the policy, as a false statement that will avoid a policy on the grounds of misrepresentation must be made willfully and with a design to deceive or defraud. 3. Evidence, knowledge, disease. Where in a suit by an insurance company seeking the cancellation of an application for reinstatement, which the company had accepted, of a policy that had been forfeited by reason of the non-payment of premiums, there was testimony showing that applicant, although under the treatment of physicians, did not know that she had a disease which the company later alleged she had at the time of making her application for reinstatement. It cannot be said that the evidence was insufficient to support the jury's findings that applicant did not know she had such disease, and there could be no fraud or intention on her part to conceal such fact. Whoa. Appeal from Harris County. Excuse me? Well, see, now we're talking about year 82. But what were we talking about 7 years ago? What were we talking about 6 years ago? What were we talking about 5 years ago? Just so happens, 6 years ago from today is what? 2017.